Good evening, everyone. We're all astonished at how much brighter this room is as we've had done some painting and new lights. Welcome to our regularly scheduled meeting of council, October 15th. Just want to start off this meeting as we do all of our meetings, just acknowledging that we are holding this gathering on the traditional territories of the Coast and Strait Salish people, specifically the Lekwungen-speaking people known today as the Esquimalt and Songhees First Nations, and that their connection to these lands continue to this day. I also want to just remind everyone that the meeting, as all of our meetings are, is live streamed. So if you come to the microphone at any point, you will be seen by people at home and recorded in our archives. So with that, we'll call the meeting to order. Our first order of business is adoption of minutes. We have minutes from the council meeting of September 30th and special council of October 7th.
Seat. Second.
Move adoption, sorry.
Move adoption.
Moved and seconded. Any discussion, omissions, changes? Yes, Councillor Appleton.
Yes, thanks. Sorry, I'm just pulling up my my minutes so that I can have them in front of me. But just in the section under reports, under new business for the September 30th?
September 30th, okay.
September 30th council minutes. Sorry, I'm just pulling it up so I can have the exact section in front of me. I just wanted to just strike one section. Sorry, just getting it now. So under section 9, new business and verbal reports, under other verbal reports, just my report back, just the language under my report out, I was just saying, it reads here, he was very disappointed to find out from staff after the fact that a small contingent turned up to protest the August 17th drag swinging score time. Could I just ask that we just strike the portion that says from staff after the fact? And I understand why that's in there, but it sort of makes it sound like staff didn't inform me until after the fact, which was true, but it wasn't intentional. So I'm just, for simplicity's sake, please.
So you move an amendment to strike that?
Yes, can I move to strike the portion of my comments in these minutes?
Is there a seconder?
Second.
Any other discussion? Seeing none, is the vote on the amendment to make that correction. All those in favor? Opposed, not opposed. Thank you. Now fixed. Any other changes? Seeing none. All right. I'll just do both minutes at the same time then. All those in favor? Opposed, not opposed. Thank you very much. My remarks are fairly brief tonight. I just, we've had a couple of outdoor activities recently. The Tour de Rock, riders coming through and finishing their journey, and the Victoria Marathon running over the weekend. And I'm just reminded of the importance of our outdoor infrastructure, or water fountains, or roads, or sidewalks, and just in supporting the outdoor activities in our communities, and how much that is appreciated and helpful in our community. And on the note of Tour de Rock, I wanted to just recognize Sandrine Perry, who's an Oak Bay Police Constable who participated in the ride this year. So the amount of fundraising done by her, through her, and with her was really phenomenal. I was able to attend with Councillor Braithwaite the unveiling of the check at the Oak Bay High School, and they alone raised over $76,000 just that school towards children's cancer, and so I just want to express my appreciation for all the work that she did on that. And I'll just last week we met as a group of Lower Island mayors for our quarterly lunch. I don't have anything too specific to say about that. I want to acknowledge how pleasant it is to have mayors that are willing to work together to accomplish things. And there's a presentation and discussion around the One City program that is undergoing, or One Planet, sorry, program that's undergoing in Saanich as a way of involving the community in climate change initiatives. So I thought that would be very helpful for us to include as part of our consideration as we look at climate change mitigation initiatives going forward. That concludes my remarks. Up next, we have item number 3, which is the public participation period. And this is a chance that anybody can come forward and address council on issues that are of interest to Oak Bay. Our procedures bylaw allows for up to 20 minutes for people to come forward. Each person allocated a maximum of 3 minutes each. And I'll just invite anybody who wishes to come forward to address council. This is a chance to do it. This is for things that are not necessarily on the agenda, although you can address things that are on the agenda if you so desire. Is there anyone who wishes to come forward to speak? Anybody wishes to come forward to speak? Oh, yep, come forward. Usually people are a bit shy to start with, so I try and give people a moment. Procedures here, if you could just state your name, your municipality of residence, and then at the end of it, just write down your name so we have a correct spelling.
Good evening. My name is Maggie Serpa, and the last name is spelled S-E-R-P-A. And I live in the vicinity of Oak Bay in Rockland, in St. Charles. I'm here to just sort of provide a comment that I took the Oak Bay Historical Walking Tour, and during that tour, it was pointed out to me the beautiful place of 1558 Beach Drive, which I understand will be some attention to it later on. And I just want to say how impressed I was by the uniqueness, the beauty, the history, the dramatic buildings that make Victoria so unique, and specifically Oak Bay. I cannot stress enough how impressive it is that this community has these kinds of buildings standing today. I don't know what the outcome will be, but it is for sure a historical building. It is for sure unique, and it is for sure something that as Victorians we should be looking at. And as we look at how to build sustainable communities, how wonderful it is that 7 families live there, old, young, middle class, working class, young people. How wonderful that it is to provide that. I myself live in a heritage building and consider it a great privilege. So tonight, when you are thinking about these issues, I want you to consider that what stands out to outsiders, because I'm a newly Victorian, is the beauty, the thoughtful consideration that has been given to these communities so that they look as they are today. Thank you.
Thank you, Ms. Serpa. We are directly addressing 1558 Beach tonight, but it is part of contained within the Heritage Control Period bylaw being considered. Is there anyone else who wishes to come speak to us at this time? Seeing anyone, so we'll come back to this table. Thank you. Thank you very much for speaking. Item number 4 on the agenda is the tree protection bylaw application for reconsideration, and I believe we have Mr. Hidley that will introduce it, and then you're welcome. If you're the applicant, then we'll have you come forward and have a chance to address council. Mr. Hidley, can you just give a brief introduction of this item?
Thank you, Your Worship. Yeah, certainly. The tree in question is located at 1718 Monteith, at the left side rear corner when you're looking at the house from the street, and borders Fireman's Park. Parks have looked at the tree and feel that the tree is healthy and is not impacting any significant structures or services. There's no new buildings or services being planned, nor is it interfering with any native species on the property. So sections 6, 1 through 11 wouldn't apply in this particular case for us to be able to issue a permit for removal. Section 612 does state to remedy an undue hardship attributable to a material and deleterious effect on the tree, on an improvement of significant value located on the subject parcel or on land adjoining the subject parcel. We have never considered fences a significant structure or an improvement of significant value, so we didn't feel that one really fit into any of Section 6 in our bylaw. Under Reconsideration Process 3 in 21.1, there is a clause there where the council can review the parks manager's interpretation, and if supported by facts and in harmony with the scheme of the bylaw, generally the language of that section in particular may substitute its own interpretation, as long as taking into consideration the species of the tree, the form of the tree, the condition of the tree, and the general density of protected trees on the subject parcel. In regards to this spruce tree, it is a 2-stemmed spruce tree. Most grow as one. It's a tree that could fall into the category of beauty is in the eye of the beholder.
We'll leave it at that, shall we? I believe the homeowners here, if and you wish to address council as well, so please come forward. And again, our usual process here is just if you can just state your name. We think we have your address.
I have a handout for you. Is that okay?
Yeah,
Do
if you could just
accept
leave
those,
one
or-
with the corporate services there,
I'll
and
do
they
that
can pass it
afterwards,
around.
if that's okay. I have a PowerPoint just to go through. So just, I'll try to be very quick. So just a brief
Did you
history.
want to hand the handout to? We just
Yeah,
if you
I
can give
brought,
it-
I brought copies for each of the council members.
Sure.
So my name is Colin Dormith, 1718 Monteith Street, just across from the fire hall. In May of this year, we applied to the district to remove the spruce tree that Mr. Hidlay mentioned. And Mr. Hidlay visited the following week and essentially told me he thought it was a healthy tree and that it's protected. And that was pretty much where we left it. But we left ourselves feeling like we weren't really, we didn't get a denial of the permit, and we didn't get a permission to go ahead. So in August, I recontacted Mr. Hidlay and just asked him if I'd heard from a neighbor we could apply for a variance, and he corrected me on the procedure. So he did send out the municipal arborist shortly thereafter, and the arborist visited our house on August 14th, and on that same day denied the permit application. This is an overhead view of the property. In the large red circle is the tree that we want to have removed. The blue circles show you that our property has a fair bit of canopy coverage already, some very large trees and some smaller trees. The white boxes are the homes around where we live, and you see green check marks beside all those homes. Those are people who are either okay with the tree coming down or enthusiastic about the tree coming down. I have some testimonials at the end and can provide emails as well. There's a letter from my immediate neighbor who says that the tree is preventing them from landscaping their yard and planting new trees of their own. As Mr. Hidlay mentioned, the tree is got multiple headers. It's very hard to find an arborist who will do a report for you on this short notice, but I did find a tree falling person who is legendary tree. His name is Aaron. And he came by on the weekend, and he said that this tree has been topped multiple times. And the first time it was topped, when it was smaller, led to the first two stems coming out that you see on the left. And in the large red circle, you see a crack, which is called included bark. And what that is that's an injury to the tree caused by the tree wishboning because it was topped and it grew those separate headers. The tree on the right is pushing up our shed. It's about a foot off the ground, and the shed is embedded in the root of the tree. It's become oversized because of those, because it's been topped and the weight's unbalanced. The tree trunk has had to grow to an oversized degree to support the unbalanced weight. This is according to the tree guy. The tree is dropping sap, a lot of sap on our house. On the left is a railing that's less than 5 years old, and it's all corroded from the sap dripping onto it from the tree. On the right, you see that the tree was topped more than once, and when it was topped again, it split off again up above. And so the tree is not growing naturally, and it's not growing naturally because it has not been treated well by previous owners. We didn't do any of this topping. There was a point Mr. Hidlay mentioned that it wasn't affecting any other trees. Well, actually, we had to take down a smaller tree a few years ago. It wasn't a protected tree, but it was dying because it was growing in the midst of that larger tree, and it wasn't able to thrive beside it, and so we took it down. So in hindsight, it was affecting other trees. The tree is pushing up our fence, and it's pushing over our fence. I have a little mark there. A city worker left a big burn mark along our fence this summer, so just a little frowny face about that, but I'm not asking for any remediation today, and I won't be. We also just feel the tree is unsafe. It creaks in the wind. We have children and dogs. Other trees in Fireman's Park have lost major branches in the last few years. Spruces, I'm not an arborist, but spruces are not meant to grow this way. they're not meant to grow all sprawled out like that with multiple headers. And so, yeah, we also feel it's we don't feel safe in our yard with that tree there. So just some of our neighbors' commentary. We can provide their emails, letters if you feel you need to see those. Thank you.
Thank you, Mr. Dormuth.
Sorry, just quickly. We are willing to plant another tree, 2 trees actually. We'd prefer them to be deciduous dogwoods. And our neighbor mentioned that they would also be willing to plant at least 1 tree in their yard as well. So if you do allow us to take down the tree, you will be getting at least 2, probably 3 in return for allowing us to do that. Thank you.
Thank you very much for your presentation. Might want to hang around for a second. There's probably likely to be questions either of council, of you, or staff. Any questions from council at this time? Yes, Councillor Braithwaite.
Actually, it's a question to Mr. Hidley. Mr. Hidley, normally when we have a location of a fence like this that borders onto municipal property, the cost of the fence is shared between the neighbor and the or I shouldn't say normally, but oftentimes, the cost of the fence is shared between the neighbor and the municipality. Is that the case in this particular one?
Mr. Hidley.
Through the mayor, thank you, Councillor Braithwaite. Not to my knowledge in this particular case. Some of the fences are shared, but I can't recall that this one was.
Thank you.
Yeah, Councillor Green.
Through you, Mayor, to Mr. Hidley. Mr. Hidley, are dogwoods a good choice? My understanding is that they are now prone to disease, and they are not. They're not the greatest tree to plant as replacement. Would I be wrong in that assumption? Thank you.
Through the mayor, no, you're not wrong, Councillor Green. Most dogwood varieties do get a fungus, in particular our native dogwood, which you actually really can't find for sale in many nurseries. But there are a lot of dogwood varieties that are more along the ornamental side that are disease resistant to this particular fungus that attacks them.
Thank you.
Councillor Patterson, then Councillor Nay.
Yes, thank you, Mayor. And through you to the resident, just wondering if when the arborist was consulted, if you asked any questions about perhaps maintenance pruning that could be done on the tree to alleviate some of the wind effects, since that there is a hollowing out on one side. I just wonder if the arborist provided any recommendations.
Yes,
Mr.
thank you.
Dormuth?
He, first of all, I'm not sure he was an arborist. I'm not sure if there's a technical license that goes. He's a tree faller. He did say that if the tree could be pruned back, if it was substantially pruned back, it would have to be topped again. That's what he said, in order to make sure it doesn't get out of balance again, or even have the balance even made worse. We actually did, when we first moved into the property 5 years ago, ask for permission from the district to prune it, and we hired a company called, I think it was called Blue Collar Tree. They were limited to anything smaller than 5 centimeters in diameter, I believe, and so there's actually branches coming out of the tree many feet that are just lopped off at 5 centimeters, and so we weren't allowed to do much of it back then. Also, so the tree might need to be retopped, according to this fellow, or some sort of cabling mechanism put in place between the headers or the leaders to keep it stable.
Thank you. Councillor Patterson, anything else? Councillor Nay.
Thank you, through your mayor. To staff, actually, I have the same question to staff that Councillor Patterson asked the applicant. I'm just wondering, in your report, you speak to the possibility that some pruning could be done on the tree. I'm just wondering if you could provide us a bit more specificity about what could be achieved if one was to engage in some pruning.
Mr.
Through
Hidley.
the mayor, thank you, Councillor Nay. Some of the pruning that could be done is some raising of the canopy, so it would let more light into the rear yard, and some shortening of some of the longer extending branches out over to the yard. In regards to the old topping cuts, etc., we inspected the tree visually from the ground, so we didn't see any decay at those previous wounds on the actual tree itself. And the nature of just how this canopy puts itself together is that both stems have branches, and the limbs intertwine with each other and are almost self-supporting, or offer a great deal of support to each individual stem in itself. But I will be the first to admit that architecturally, it's not an ideal situation for a conifer to grow this way, but many do, and many do quite happily.
Thank you.
A
Councillor
follow-up
Nay?
question. Through you, Mayor, to staff again. Mr. Hidley, the idea around the bylaw allows us to remedy an undue hardship, and you've spoken about fences not being a significant structure. So the applicant has showed us the damage that's underway with the shed. Is a shed also not considered a significant structure? Would that be the case?
Through the mayor, it would depend on the foundation. If the shed was actually on a solid poured foundation, much like a detached garage, then it would be considered a significant structure. But a fence or a shed that is just built on actual blocks that could be moved would not be.
Okay, and then just one thing. So the intention would be then that the shed should be moved out of the area that's out of the proximity of the tree that's causing the damage. Would that be so?
That could be a possibility, or have the foundation that it currently sits on modified to accommodate the tree too. And I would say the same for the fence.
Thank you.
Thank you, Councillor Nay. Any other questions or comments or motion is allowed at this point?
Oh, sorry.
I think you can have a seat, Mr. Dormuth, and we'll. Councillor Appleton,
I'm going to make a motion that the application for reconsideration be denied, please.
is there a seconder?
Second.
There's a mover and a seconder. You made the motion. Do you wish to motivate?
Thank you, Your Worship. As council is aware, we've dealt with a couple of these reconsiderations. In the same way that we have considered the idea of relative safety of a tree as a consideration for removal, I'm just pointing out some issues in this case which also get us involved in adjudicating whether or not something is the aesthetics of a tree or the relative impacts of a tree by the leaves and needles that it drops or these kinds of things. So I feel that that's a really difficult place for us to go in terms of what the relative impact for inconvenience of material that's dropped by a tree is on a given landowner. I don't think we want to get involved in doing those things. And as it has been with other reconsideration situations, I think we really need to go with the professional opinion of the district's arborist on this, as it has been before. And also, with respect to the structures impacted, and I recognize that there is a direct impact on the fence and the shed in this case, but it's also, again, reasonable to expect that large, healthy trees in the district will sometimes impact those types of structures. So if we take it as a given that in situations where remediation is possible in terms of adjusting the fence, moving the shed, if we say that those things are not appropriate and that we would approve removal in situations where remediation is possible, I think that's also a difficult situation to put us in, because at what point do you draw the line between what is essentially what is inconvenient? If it inconveniences a structure, if it's immediately subject to removal, I think that's a bit of a dangerous road to go down, because we don't have, in some cases, we don't have giant lots, we don't have significant space for significant trees. We want to retain that tree. Accommodation by some of these ancillary structures and these works might be necessary in some cases. So.
Thank you, Councillor Appleton. Councillor Green, you seconded. You wish to add anything to the discussion?
No, I would agree with my colleague and just add that it's very difficult as well for us to be judging hardship. That's also a difficult subjective call.
Please don't yell out, though. It's we have to have this conversation here.
But again, we rely heavily on our professionals, and I'm loath to take down a healthy tree in Oak Bay at a time when we're all concerned about climate change and the contribution that mature trees make to our local environment. So I would echo my colleagues' comments as well. Thank you.
Is there any other discussion? Councillor Nay?
I guess what I would say is I find this a bit tricky because I mean our staff have even pointed out that this isn't an ideal way for the tree to be growing, and it's causing difficulty. And as you look at the tree, you can see that there are branches dangling out that appear to be somewhat precarious, but I think I go along with my council colleagues. I'd really like to see what would happen if the applicant underwent a real severe management program with this tree, because it does look like it's been unattended in many sense, so it's been allowed to go freehold. So, yeah, so with that, I'm in favor of the motion.
Any other comments? Seeing none, I would say if the applicant was still here, it's worth keeping an eye on these trees for sure. If there's any future signs of decay or things, and there's pictures he shared of concern. I think they're worthy of note, and appreciate the work that their staff does to keep an eye on these things and work with applicants to move things forward. With that, I'll call the question. All those in favor? Opposed? Not opposed. Thank you very much. Thank you, Mr. Headley. We have a Section 57 notice at 1587 Monterey Avenue. I believe this is a report from Mr. Anderson, Director of Building and Planning. If you could just introduce this item.
Yes, thank you, Your Worship, members of Council. The report recommends Section 57 Community Charter notice on title be placed against the property at 1587 Monterey Avenue, and that's for failure to comply with District of Oak Bay Zoning Bylaw 3531, Section 415.1, which prohibits the use of more than 25% of the front yard as paved surface. So the purpose of a bylaw contravention notice on title is to advise those with an interest in the property of the regulations contravened, to provide disclosure to future purchasers, and to protect taxpayers against potential claims with regard to the regulations contravened. With respect to this evening's meeting, the property owner has been notified of Council's consideration of a potential notice on title for the property, and the recommendation is that option 1 be considered by Council. Thank you.
Thank you, Mr. Anderson. Just out of curiosity, is the owner of the house here tonight? I'm not seeing them, so thank you, Mr. Anderson. Are there any questions of Councillor Green?
Through you, Mayor, to Mr. Anderson. Mr. Anderson, what is the status currently of your relationship in terms of working with the owner? Are they willing to work with you to comply? Do you have any information on that?
Yes.
Thank you.
When Council receives this before them at a Council meeting, it represents a process that we've been engaged in toward voluntary compliance with the property owners, and we go through a fairly extensive process to seek that compliance, and we end up basically with providing letters, a set of 3 letters that basically indicate that here's the issue formally, because there's been no action taken based on our verbal conversations with them. And then there's a time period that's provided, and then with no action, we provide a letter saying there's no action been taken. And we continue to obviously seek voluntary compliance in that process, but we end up basically with a final letter saying we're proposing that this notice on title be placed and it's going to, a council meeting. So I should mention that even with a notice on title, we still would seek out voluntary compliance with the owners. But usually when we're here, we've not had success to date with any activity or actions taken by the property owners.
Thank you, Mr. Anderson. Yeah, Councillor Green.
Sorry, just one supplementary question through you. Mr. Anderson, has the owner actually contacted the municipality or met with you or your staff to date?
So we have had contact with what we understand to be a resident at the property, not the registered owner. But to our knowledge, they're not a formal representative of the owner, but they've been the ones that we've been in contact. We've not been able to have contact with the registered owner of the property.
Thank you.
Councillor Patterson.
Thank you, Mayor. Another question, just following up, because I feel questions quite often from residents in the community in that they are not required to take out permits to do landscaping. And in instances like this where they hire a landscaper and a landscaper makes recommendations to them and they follow the landscaping and find themselves in this situation. I think it's very confusing. And I don't have an answer as to how you can get around that, but I can certainly understand the difficulty of the homeowner. And in this case, I would think that they did spend quite a bit of money in order to get work done that doesn't comply. So I'm wondering if perhaps this isn't something that staff could come forward at some point in the future with a recommendation as to how we can bring greater clarity to the process. So often fences go up or the rocks go in, and we don't seem to get much cooperation from landscape companies necessarily. So somehow there seems to be just a gap in the communication. We find ourselves in these situations. So if there's a way possible in the future, I would like to hear from staff on that too.
Mr. Anderson, do you have any comments on that at this point?
Well, I would say that we would hope and expect that people would make themselves aware of bylaws when they are undertaking works, and particularly something this significant with a landscape contractor involved. They should know in Oak Bay that this is in place and that you can't proceed to cover the entire front yard with gravel effectively. So regarding going forward, again, every opportunity we have when there are inquiries, we are able to provide people with that information. But it's ignorance, if you will, is not a defense when it comes to bylaws in the community.
Thank you. Any other questions, comments?
No, I'll make the motion that notice be registered with the Land Title and Survey Authority against the land at 1587 Monterey Avenue with a legal description of Lot 11, Block 2, Section 69, Victoria District Plan 919 for failure to comply with the District of Oak Bay Zoning Bylaw 3531.
Second.
Moved and seconded. Any further discussion? My only question on this one is to Mr. Anderson. The wording of paving that's in our bylaw that kind of covers this piece of it. Do we have a sort of clear enough guidelines? I mean, I would assume if this landscaping was done, but there was lots of grasses and bushes planted around it, and this was an understory, this would be allowed. Is there any sort of sense of guidelines for what constitutes paving versus just sort of a rock features within a garden? Is there a sense of that?
Well, we do have a definition in the bylaw that speaks to what paved surface is, so that's part of that zoning bylaw and being aware of that. But the key is that of those materials, and all asphalt, macadam, concrete, interlocking bricks, paving stone, gravel, or other similar material, are not allowed to cover more than 25% of that front. So you could do a landscaping plan interspersed with gravel, for example, and landscape features, and as long as you're within the 25%, you're fine. We did have that discussion with the representative as an alternative, and to no avail.
In short, green is good. Yes. Okay. Green is good. All right. With that motion on the table, all those in favor? Opposed? And opposed. Thank you very much. Item number 6, we have another Section 57 notice on 2023 Newton Street. Mr. Anderson, I believe this is yours again.
Yes. Thank you, Worship, members of council. Again, the report outlines Section 57 Community Charter notice on title be registered against the land at 2023 Newton Street in Victoria, and that's for failure to comply with the District of Oak Bay Zoning Bylaw 3531, Building Bylaw number 4247, and the British Columbia Building Code, and which contraventions relate to the property being used as a rooming house. As I noted, the purpose of registering bylaw contravention notice on title is to advise those with an interest in property of the regulations contravened, to provide disclosure to future purchasers, and to protect taxpayers against potential claims with regard to regulations contravened. We have notified the property owner that this is coming before council this evening. I should note that we have a history with this property, and there was work without permit. A permit was taken out but went to expiry. We have then more recently had complaints and acted on that in terms of an inspection And there are, again, works that have been completed over the years that are not in compliance with our building bylaw. And we also, through the complaints, identified that there were illegal suites in this residence. So, and the option recommended is that a notice on title be placed on the property. Thank you.
Thank you, Mr. Anderson. Councillor Braithwaite?
Thank you. And
Just before you start, is the owner here tonight? Thank you.
through you to Mr. Anderson. So when you say that it's being used as a rooming house with suites, etc., are we not able to close that down and have them remove the people from the rooming house, or are we only is our only course of action to put a notice on title?
Yeah, in terms of the process, as I mentioned, we work through voluntary compliance. If we're not able to achieve that, we move to notice on title. Council does have the option of considering proceeding through court actions to try and address this issue, and that's our next option, if you will.
Thank you.
I just procedurally here, I'll seek some advice from staff. If the owner's here, would you like to address council as part of this? I think that's my wish is that if you do, then please, why don't you come forward now and just lay out, if you don't mind, articulate your case here to council.
I actually brought some material too to hand out. Actually, just one thing. I have this copy so I can keep on track.
Thank you. And again, if you just, for the record, state your name and municipality of residence at the beginning of your...
Yeah, do you want me to print it down, or is it all right?
Probably you can print it down as well. That would be helpful.
Okay. So, Oak Bay, Nick Jacquet.
So I didn't quite get your name.
Nick, N-I-C-K, Jacquet.
Thank you, Mr. Jacquet.
Bay. Boom. There we go. I don't know really exactly where to start. It's been I had a bunch of tenants who were living downstairs, and they were supposed to move out, and then they kept on changing their mind, and then there was a date they had to move out, and they said they weren't going to move out, and then we said, well, you've already agreed to move out, and it just went into a big circle, and we had to actually they actually called the police. Then they left halfway through the month. They didn't give us a notice of departure, and then we went to the Residential Tenancy Board, and now we have to put a claim in through small claims court to get the monies back from rental income and so forth. But that was only half of it. The other half came when Ed Boogards came and knocked on our door and asked to do an inspection of the house. We don't have a rooming house. I mean, I think the words that comes out of this guy's mouth is actually is amazing. So I had my neighbor come by, who is for 37 years, he's been the chief inspector for Vancouver Island Health, and you met him too, and he ran into the same problems with the bylaw inspectors here. And then my
Sorry,
other neighbor,
if you don't mind, we're
Yeah.
not here to sort of disparage someone who's not here to defend himself or
Well,
talk about that. So
well, I
we're
mean,
here
he's
specific.
put all these things forward, and you were there too at the meeting, Kevin.
So if I might, just
Yeah.
if you could address yourself to the merits of the complaints and whether or not they actually are not, and
Okay,
it's just
sure.
not to the staff involved, if you don't mind.
All right, sure.
Thank you, Mr.
So a
Yap.
bit of the history. I live in the 1948, potentially 47, potentially 46 house. It's a legal non-conforming house. We have no drawings for it. I was told that the drawings were on file at the council, so I took out some drawings. These aren't the drawings for my house. I did find that there was one set of drawings for the house in 1978 that were taken out for the attic space when rooms were built in upstairs. Other than that, there was my permit, which I took out, which I was told to do, which I didn't realize I didn't really have to, because it was for $50. I replaced a few 2x4s that had burnt at a fire in the backyard on the deck. I feel like I've been misled by staff all the way through, and I'm going to go through a bit of this whole episode here with you. communication, they're going to say there's been no work, no activity done on this file, but I can show you from the index here, I've sent 4 messages off to Ed Bugard, 4 to Bruce Anderson, and I've copied him also on the 4 that I said to Ed, and I've sent you 7, trying to get clarity on what I am accountable for and what I'm not accountable for, okay? And if you go over here to the first page, here's the receipt of actually taking out, paying for some drawings that aren't mine. There are no drawings of the house. In fact, what I've learned from talking to other people, that there's no drawings for any of the area of my houses are in. Yet when the bylaw officer comes, the first thing he said is, these are the drawings, your house has to look like this. Well, it's not true. It's not true because these aren't the drawings of my house. And this is where it gets murkier. And then from further on, he gave me a ticket. And then you can see on the second page, he gave me a ticket for, I think, for $200 for having a rooming house. And then he promptly canceled the ticket. And then in the message here, he says the ticket has been canceled. And then another message, he tells me I didn't cancel the ticket. So I have these all in error. He says the ticket was not issued in error, but it says written right over it on the 4th page that the ticket was issued in error. The 3rd page here, this is the mail I get from the District of OK. It says 2032. My address is 2023. I happen to get these 2 because my neighbor came over and said, hey, Nick, these must be for you. All the rest of the mail that Ed says, or from Bruce Anderson, I don't get. Okay? Now, I'm sure that they've tried to communicate with me and they've done their due diligence just like they did with the last case on Monteith, and they've sent in messages and practiced their due diligence of sending in 3 messages about getting the client, the customer, come up to working with Bylaw, but I wonder now, do they actually have the right address? So here, on the next page here, this one here, where it says copy here, it says clearly in it, please cancel ticket issued in error. This is what I deal with when I have to communicate with the bylaw officer. And I've mentioned this to you in talking, so.
So, Mr. Jaquette,
Yeah.
not to preclude you from making a case for yourself here, but
Yeah.
we have in front of us a set of I guess, statements by the staff that there's work being done without permits, and those permits are required to be brought up to compliance. And you're disputing that fact,
Yeah,
are you?
Yeah, I am. I haven't done anything. I haven't been there. Sometimes I'm away for 6 months. There's no work that I have done under my ownership of the house. I bought the house. It had a suite in the basement as a mortgage helper. It was like that from day one. And that sort of thing. I don't know when the work was done in the house. I assume that with the bathroom upstairs, it was done on the same time this drawing is, and they put it in there. But I have no fixed date. You didn't catch me with a hammer and a skill saw saying, oh, you've been doing all this work. Well, we haven't been doing any work. We've just been living in the house, and I've rented out the downstairs. And that's it. And I have the upstairs to myself. I've had my daughter's friends living with me because they didn't have a place to live. It's not a rooming house by any measure.
Okay.
Do you want to keep going?
Sure. If it refers,
Yeah.
I mean, I think you've got the crux of what your concern is, but go ahead.
So my crux is that I can't get a straight answer out of any of the staff members. I can't get it out of only on the 29th by Bruce Anderson here, he finally addresses the question, what am I responsible for? And he goes, Mr. Jaquette, as a current owner of the property, you have the responsibility for the use and condition of the house to meet the BC Building Code, as well as the district bylaws. It is the current use and condition of the house that we need to work on, regardless of whether this was undertaken by a previous owner, the original owner. Okay, I hope this clarifies this question and welcomes the opportunity to work with you. This is the 29th. I've been asking this question since June. What am I responsible for? And then in the last page here, you can see I asked BC Building Code here. I asked them a question, what am I responsible for? Because I started to get these questions come. The BC Building Code says on this page right here, it says the Building Code doesn't regulate existing building use, nor does it regulate how you use the spaces in any building so long as its uses are in keeping with the classification under which it was designed and built, a residential house. He says I got to build it up to the current code of 2019 or to 1947. Is it Egress from 1947 or is it Egress from 2019? I can't work with this. I mean, you have to have some kind of.
So we can perhaps raise that question with staff on your behalf here, and so your argument here, just want to bring it to a bit of a conclusion
sure.
here, is that you're disputing the fact that you have not done any work on the building,
That's right.
and that it is the current safe, at least to appropriate safety codes.
That's right.
Piece.
Yeah, and so they said something about smoke alarms, and I didn't know, so I went out and bought interconnected smoke alarms, and essentially, and there's a receipt of it here, I haven't had anybody independently inspect that, but you push a button and all the alarms go off in the house, and they communicate through something like Bluetooth. Or I bought those to meet that thing. I don't even know if I was supposed to or not, but I've done that. And then I've added at the very end of it, which my partner here told me about, is non-conforming use, and that my house fits under this. And why they won't tell me, well, this or that, but they don't work with you as the person who pays the taxes is here. They sit back and they just send you these messages saying, we see that nothing has been
Again,
done
can we
on the
just
file."
focus on the facts of the matter and not on complaint? I mean, I appreciate
Yeah,
you
well,
know
it's
the
frustrating.
Point of order.
I think that this is. I can appreciate it's frustrating, but we're still here focused on the merits of this particular the concerns being raised. Yes, sorry, Councillor Green.
I'm concerned about the allegations towards staff, and I would like that not to be the case.
Yeah, you're welcome to reach out to me or to senior management and raise concerns of non-pieces. When we've communicated in the past, I've requested that you escalate to the appropriate management. So it sounds like this is not to your satisfaction still. So there are still mechanisms to raise that internally.
Yeah.
There is management structure here to do that. But this is not the right place to.
But August 29th was the last time. I've messaged him since May. Where do we draw the line?
Fair enough. You're allowed to.
Timely professional service.
Mr. Chiquette, just in fairness, there's a place to do that. This is. If you're complaining about staff performance or their behavior, this is not the right place. We're here to address there is a Section 57 recommendation here as a tool by which to essentially compel compliance with building deficiencies in buildings. So that's essentially what we're dealing with. So if we can maybe keep our focus on that particular issue.
Sure. So again, I haven't started any construction in the time that I've owned this house, and I've bought smoke detectors because they've thought that they've told me that I needed to have interconnected smoke detectors. They say that the windows aren't up to standards, but they've been the same windows since 1947. I'm not sure really what else I can do to work with the staff when I have to, behind the scenes, have to check whether this is actually something I need to do.
May I just ask a question? Have you had the involvement of any certified contractors or anything else go through and assist you with this process?
Yeah, so I did. I asked about the staircase. So the staircase, they said they can't put a staircase into code because there's something about this. You come up to a level and you can't go to the right. You have to go straight through, and there has to be a safe landing. And they said, so they can't put a staircase in where it was originally put. And they said, well, we can put one in the back of the house, and then it comes with a huge costly factor. It's and it's not something that can happen right away. I don't know how many of you can get a good contractor to your house in 30 days to work it out, but that's really the stickler of all of it is the staircase, is trying to figure out a way to get something. And it's not that I'm not willing to put a staircase in. If you said to me, okay, well, that's actually what we really need to do, and you're willing to work with me and say, okay, well, let's put one back in there, help me. I mean, how much time it took me to get all this information? I mean, they could have sat back and said, well, why don't you put one over there, and then we'd have something to work with. But I haven't had any of that.
Thank you, Mr. Chiquette. Anything else you want to add before we come back to this table?
I just wonder how many other people have gone through this, that's all.
All right, thank you. So, Mr. Anderson, I'll go back to you if there's anything you want to add. It seems to me this has been a long process in place. Perhaps you can give us some update on some sense of timeline here of when this started, and perhaps also just address willingness of staff to assist people with their building, because there are some limits to what we can do in terms of advice, but there's give it to you, Mr. Anderson.
Yeah, certainly, Your Worship. I mean, as I noted back in 2014, there were violations identified, and an action was taken, as noted, to take out a building permit to address the work that was done without permit. But that permit did expire in 2015. There was no bylaw enforcement action taken in that period until recently, when a complaint was received about the occupancy of the building, and at that time the bylaw enforcement officer was able to inspect the residence, and it was at that point that we were able to confirm the deficiencies in terms of the building code, and we've itemized those in the report. My understanding of our initial contact with Mr. Jacquet was his position is that he didn't conduct those works that may or may not be up to building code standard, and so that he wasn't, as indicated, interested or willing to make any of those changes and bring that up to code or have inspections done to determine whether or not items installed were installed correctly. So we're left with an owner who does not want to proceed to bring the residents up to code, and the position that we would take is that, given that we're aware and there's no interest in voluntary compliance, we bring this forward to council for consideration of placing a notice on title.
Thank you, Mr. Anderson. Councillor Green, then Councillor Ney.
Through you, Mayor, to Mr. Anderson. Is the home owner occupied?
To my knowledge, according to Mr. Jacquet, it is, but I believe that's variously over the years, but that's just my understanding.
And Mr. Anderson, through you, Mayor, do you know how long Mr. Jacquet has owned the home? Was he the owner in 2014?
I believe so, yes.
Okay. Thank you. Thank you.
Thank you. But just for the record, not an affirmation was that it was owner occupied for Mr. Jacquet in the audience. Councillor Ney, you had a...
Thank you, through you, Mayor, to staff. Just a couple questions. One around the use. So I think you've used the word rooming house in the report, but I can't find it right now. But I did hear you say it a couple of times, Mr. Anderson. What is a rooming house based on our zoning bylaws? How is it defined?
More than two unrelated.
Okay.
Three?
Is it?
Two or more. Sorry. My bad.
Okay. And that's, as I think what you're saying here, and you've said in the report that it's being, I think there were, what are the number of people living in the house? Do we know? It's being used to have more than three
at this point,
unrelated people.
Can I just jump in here for a second, because I don't know, is the notice of title is not related to the number of residents currently, correct? Which is a transitory piece. The notice of title is on the building permits.
It's related to a suite being in the house, yeah, which contravenes the zoning bylaw.
Okay, thank you.
So is that use, or I was kind of unsure about that, but I thought the issues were both use and the condition not compliant with
Yes.
code.
That's
so
correct.
Use is one of them.
Yes.
So is that okay, Mr. Mayor? I could pursue that. Okay. So the use. So what we have here is a situation where more than three unrelated people are living in the home. That is one issue.
That's our understanding. Yes.
Okay. And then with regards to the issues of non-compliance, so the need for egress windows, which came up I understand, in 2014, if I have that correct. Does that mean a person living in a bedroom without a window that opens up? Is that what that means?
Yeah, they need to be available for exit for people in a bedroom, and it needs to be of a size as well for people to be able to safely exit from the bedroom, and that's a building code requirement.
Right. And that's what seems to be you've listed a number of things that are of safety issues, and that is one of the safety issues that has not yet been complied with.
That's correct.
Okay.
Thank you, Councillor Ney. Councillor Braithwaite.
So just kind of going along that, if this is based on the requirement that there's, or that if this is based on the fact that there's an illegal suite in the basement and the notice of title is going on because of that, would they be required to take the suite out if this was approved?
The notice on title, as I said, just provides notice of the contravention to the bylaws.
But that would be that I thought I heard you say that was based also on the suite that was there as well.
Right, but the notice doesn't. It's a notice on title. It's not doesn't require action. We again seek voluntary compliance.
Okay, so if there was no voluntary compliance, because if there's going on what Councillor Ney said, that the egress for the windows, would we still allow this illegal suite to be used if the egress for the windows was not taken care of?
Well, we don't allow the illegal suite. So I mean that's.
Well, right. So that goes back to the beginning of my question. So would we actually then ask for the suite to be taken out as a next step, perhaps?
We would.
Councillor Green.
Through you, Mayor, to Mr. Anderson. Mr. Anderson, just two questions. One is, if this owner fails to comply, and certainly there appears to be some issues around compliance, what is the risk to the municipality, ultimately the liability? And secondly, beyond the Section 67, are there any other measures that we can take as a municipality to bring this house into compliance? Thank you.
The latter question, again, as I mentioned in the previous file, we do have the opportunity or the option to pursue through the courts action related to this, and in terms of the risk, I believe that our actions in terms of seeking compliance and considering notice on title are the actions that a municipality needs to undertake to limit the risk of the municipality.
Thank you.
Any other questions? If you indulge me, I'm just going to invite Mr. Jacquet back up because there was a question raised that there's no answer to, and that is, are there tenants in the building currently? You can either just say a number and I can repeat it, or if you want to come up and answer the question, you're welcome to do so. So at this time, the answer was there are no tenants in the building. Thank you. Are there any other questions, Councillor Green?
Just one further question of Mr. Jacquet, through you, Mayor. Up to how many tenants have you had in the building previously, Mr. Jacquet?
I had 3 students living downstairs.
Okay, up to 3
Thank
students
you.
is maximum. Thank you. Just repeating the answers because people at home can't hear answers from the audience, so I just want to make sure that we have it on the record. So 3 was the answer.
So
Councillor
I'll
Braithwaite?
make the motion that notice be registered at the Land Title and Survey Authority against land at 2023 Newton Street, Victoria, BC, with a land description of Lot 6, Block 2, Section 28, Victoria District Plan 1154 for failure to comply with the District of Oak Bay Building Bylaw number 4247, Zoning Bylaw number 3531, and the British Columbia Building Code, which contravention related to the work without permit.
Second.
We have a mover and a seconder. Is there any further discussion? Councillor Ney? And then Councillor Green?
Motivate, or, sorry, I don't, yeah, we're good. Okay, sorry, Mr.
Go ahead.
Just another question to staff, if I may.
You may.
If this were to go through, Mr. Anderson, if the owner of the property, was fully compliant with our zoning bylaws and the use of the property and building code, etc., could that then be removed from the property?
Yes, they would apply to have us remove the notice on title.
Thank you.
Thank you, Mr. Anderson. Councillor Patterson?
Thank you, Mayor, and to our staff through you. My concern is that the first notice that was issued was in 2014, and it was by the Oak Bay Fire Department because of an incident that occurred there. And so my concern, of course, is there has been continued use of the basement location for several years. And so just even putting this registration against the title, how do we try to move steps forward to not having a continued unsafe occupancy in the building?
Mr. Anderson, is that a question you can answer?
Again, these are the steps that the municipality can take toward that direction, and so we're, as staff, recommending them.
Thank you, Mr. Anderson. Councillor Green?
Yes, thank you. I'm going to support this motion for a number of reasons. In reading your report, and thank you very much, Mr. Anderson, and thank you for answering all the questions. My biggest concern are two things. That's public health and safety. If contraventions are not rectified for compliance, we've answered the question, what are the risks to the municipality? But the owner should be thinking about his own risks in this case. In terms of any injury that occurs on his property because of non-compliance. Electrical, I'm concerned about fire, lack of egress, fire and safety. Stairwell removal, fire and safety. Plumbing deficiencies, health. And so these are compelling issues for me. And I guess finally, this is a really good example of why I think Oak Bay needs to regulate secondary suites when we come across an issue like this one. And I would encourage the owner to try and work with the municipality. It will be in the best interest of the owner, but more importantly, it will be in the best interest of any potential tenant that he has in the house. Thank you.
Thank you, Councillor Green. Any further discussion? I'll just make a short comment. I can hear the frustration in the owner's voice about feeling there needs to be more advice and more guidance given. It sounds like it's a complicated situation with an old house and lack of drawings. But I would still encourage that conversation to happen, and I do have every faith that the staff can help, although ultimately most of these situations end up being, people hire a contractor to give overarching guidance to bring it up into compliance, and the staff approve those. Our staff are not able to do site inspections and make specific recommendations in those situations. So I do believe if there are ongoing concerns, any concerns from the owner, I would encourage them to reach out to senior management, to Ms. Varela, CAO, if there's to register those. But with that, I will have nothing else to add. Anything else? Any other comments, questions? Seeing none, I'll call the question. All those in favor? Opposed, not opposed. It's applied. Moving on to item number 7, tender award for LED streetlight project 2019, a somewhat more straightforward item, I believe, with Mr. Brozic as our manager of public works here to give an overview of the tender.
Through you, Your Honor. The district is completing the LED streetlight project. Oak Bay's plan is to replace streetlights with a power output greater than 70 watts, and the power savings of the new lights is approximately 60% in comparison to the old bulbs. In this part of the project, approximately 356 LED streetlights and fixtures will be replaced by Oak Bay Public Works electricians. So after issuing a request for quote for these materials, submissions were received from 6 companies. Staff evaluated each proposal and recommend to council to award section 1 to EB Horseman and section 2 be awarded to Echo Electric.
Thank you, Mr. Brozic. Councillor Ney.
Through you, Mayor, thank you very much, Mr. Brozak, for the report. And I realize we're here to approve the numbers, the the quotes that have been provided by the various bidders. And this all makes sense to me. But the one question I have has to do with you state in your report that there's been very little negative feedback on the LED lights. I'm just wondering what the nature of any feedback might be.
Mr. Brozick?
So this whole process started in 2014 with 100 test samples throughout the district through 2014 to 2015 before we ordered our first 500 set. That first 100, the electricians went out, this was before I started, and talked to some of the residents within that corridor, and most of the residents, or my understanding is only 2 or 3 residents didn't like the looks of the light. But since then we've replaced just over 1,100 fixtures and bulbs, and in the last 2 years there's been very little negative feedback. Initially, when it first came out, some people were concerned about the brightness when you stare up at the light, but those calls, as pretty much all of Victoria changes to LED lights, are pretty much non-existent now.
Just one more follow-up. Have most of the other districts converted to the LED?
They're in a process of doing that right now.
Okay, thank you.
Councillor Patterson?
Yes, thank you. And thank you for the report, Mr. Brozak. I was just wondering about, in Section 2, there's such a wide variance in the pricing from the 17,000 low bid to the 71,000 high bid, and I'm just wondering if there's any comments Mr. Brozak would like to make, and in why there's such a wide swing in those tender amounts.
Mr. Brozick or Mr. Haran, whoever wishes to answer that.
Yeah, Section 2 covers post-top luminaries. So there's a big difference in basically the design that the different people submitted. There's a huge discrepancy in prices just based on the look of the post-top luminaries.
So it's like buying a lamp for home.
Yeah.
Any other, Councillor Braithwaite and Councillor Appleton?
Just a quick question. Is there any chance for grants as far as replacing these bulbs go, or is that kind of all gone now and it would have happened when we first started doing it in 2014?
Mr. Brozick?
Yeah, BC Hydro had a 5-year plan which started in 2015 to pay up to 40% of the replacement of the LED bulbs, of which we jumped onto that immediately, and we were going to do it in a 3-year process. We accelerated year 1 and year 2, but within a year and a half, BC Hydro spent all the money in for their 5-year replacement program, so there's none available right now.
Councillor Appleton?
Thank you, Your Worship. Through you to staff. Are the post-top luminaries for the Uplands light fixtures, or are we still not? I can't remember what the plan was for the Uplands light fixtures and whether those need to be taken separately.
Yeah, there's currently no plan for the Uplands area replacing those bulbs. They're actually a low wattage 35 watt type bulb, and I think it'll be a process of major consultation to figure out what we want to do in the Uplands in the future.
Thank you.
Thank you, Councillor Appleton.
I'll move the recommendation that it's awarded to EV Horseman for $43,735, and Section 2 be awarded to eCall Electric for $17,473.20.
Second.
Moved and seconded. Is that my recollection of this? This is considerably less expensive than the first set of bulbs was coming through as well. Is that correct? Do you recall what the original costs were? If you don't, I don't want to waste time on it. I was out of curiosity.
So Your Worship, I can answer your question, but we tried to just converse here because I can't recall in the original reports whether we included our own forces labor costs in the budget. So I can't give you an apples to apples comparison at this time, but I can recall that in 2016 it was approximately 140,000 is what the scope of the project was at that time. So yes, it's less now, but again, I'll have to go back and check if where the labor costs were added to that project.
Thank you very much. Thank you. Any other questions, comments? No. All those in favor? Opposed? None opposed. Thank you very much. We have item number 8, tender award for sanitary sewer and storm main lining. Is this Mr. Burzik? Mr. Haran is reaching for the microphone.
Thank you, Worship. Since 2015 actually, the district has been completing a low-impact, cost-effective sewer and storm main rehabilitation program, and that's the cured-in-place pipelining. So it's a technology or a technique which allows us to rehabilitate storm and sewer mains without an open-cut trench, and that lets us effectively extend the life for a sewer pipe up to 50 years at about roughly a third of the cost, give or take, depending on the complexity of the individual projects. So it's not appropriate in all cases, but it is a major part of our sewer rehabilitation program. So we completed a tender process for this year's program in accordance with the district's standards and their best practices. We had 2 bids from excellent contractors that we worked with before. So staff is recommending that the contract be awarded to Institute Forum Technologies in the amount of $408,137. Thank you.
Thank you, Mr. Haran. Are there questions of staff? Councillor Braithwaite?
Just out of curiosity, when do you think the work will start?
The work will start as soon, assuming that the council passes the recommendation tonight. I'll be issuing a notice to proceed to the contractor, and the substantial completion needs to be done, if I recall correctly, by 1st of March 2020.
Thank you.
Thank you. Councillor Green? Please.
I'm prepared to make a motion then so that you can get on with the work, Mr. Han. I will move the staff recommendation that the contract for the sanitary sewer and storm drain mainlining be awarded to Institute Forum Technologies Limited in accordance with their tender submission in the amount of $408,137 excluding GST for 2019.
Second.
Moved and seconded. Any other discussion? Seeing any, all those in favor? Opposed? None opposed. Thank you, Mr. Haran, for that. And that's good news. Oak Bay Heritage Commission minutes of September 10th. Moved and seconded. Moved to receipt. Any discussion? Seeing none, all those in favor? Opposed? None opposed. Thank you. Item number 10, new business and verbal reports. Any new business? Seeing none, report on the Capital Regional District. I don't have any substantial report. I already reported on the housing piece that will be coming, and we are looking at an I&I, speaking of sewers, report coming to the core area liquid waste coming up in terms of where the region is currently sitting. So on to other verbal reports of members of council who wish to speak to any of the other activities they're undertaking. Councillor Patterson.
Yes, thank you, Mayor. I did attend the provincial stakeholder roundtable on a framework for accessibility legislation. There were representatives from the province, local governments, and certainly from the stakeholders that are really pushing very hard for this. As part of the discussions, Minister Simpson, who was there, said that the target for the province of BC is to have legislation in place by 2020. And so they're trying to fast track it. It shouldn't be that arduous a task. There are actually other provinces in Canada that enacted legislation years ago, so we will be catching up. But this will certainly support the federal legislation that is now in place. And included in the discussions were a piece of the legislation will be focused around best practices, and those areas will be for service delivery, employment, built environment, information and communications, and transportation. So I would expect that as we work through our housing framework housing plan that we're working on. This is something that we should definitely be taking into consideration because it will affect the municipality going forward. And to that end, should council or staff wish to host any stakeholder roundtables within this district, there are $2,000 grants available to us through Spark BC to have discussions within the local municipalities should we work forward. But I think that it's very, very important that we, if this is not already included in the work that the consultants are doing on our behalf for the housing plan, that we need to put it on the radar and somehow bring that into consideration at the same time because it'll be coming up fast. Thank you.
Thank you, Councillor Patterson. Anyone else with any updates? Seeing none, I will move on to item number 11. It's just a summary. Item number 12, property tax exemption bylaw. Mrs. Councillor Patterson.
Sorry, if I can just, I can't forget this, the upcoming heritage lectures.
Oh, yes, thank you.
Which were really, really popular, the last ones that ran. October 16th, 7 p.m., Windsor Pavilion presents St. Patrick Street with speakers Robert Taylor, Janet Morningstar, and Arifin Graham. And on October 24th at 2 p.m., the Oak Bay Library presentations, that is The Gift of Famine with the speaker John Flanagan. Thank you.
Thank you, Councillor Patterson. Thank you for that. I would have, yes, regretted not having the chance to have that brought forward. So, sorry, back on to item number 12, property tax exemption bylaw.
Move adoption of bylaw 4737, property tax exemption bylaw 2019.
Moved. Is there a seconder?
Second.
Moved and seconded. Any discussion? I guess we don't really normally debate adoption motions, so all those in favor? Opposed? None opposed. Thank you. We have item number 13, Heritage Control Period Bylaw for Prospect HCA. Mr. Anderson, I believe you would be introducing this.
Yes. Thank you, Worship, members of Council. Council may recall at its meeting of September 30th, 2019, a report was provided by staff regarding a Heritage Control Period Bylaw. Council subsequently gave direction to staff to bring forward a bylaw for consideration of the same. The Heritage Control Period Bylaw that's before you is for the proposed Prospect Heritage Conservation Area. It's a temporary protection tool that allows for preparation of the Heritage Conservation Area and to protect heritage value of this area of the district. The Heritage Protection Tool is authorized by Section 608 of the Local Government Act. It's enacted through the adoption of a bylaw, provides temporary protection for a period of up to 1 year from the date of adoption of the bylaw. With respect to the bylaw itself, it basically sets out that control period. It also provides for temporary protection, but included in the bylaw is the requirement for a heritage alteration permit should any heritage alterations be proposed within that time period and under this control period. Those include where there's demolition or relocation of a principal building or accessory building, or any portion of a principal building or accessory building. Alteration to landscape features that have heritage significance according to the Statement of Significance for the Prospect Heritage Conservation Area dated March 7th, 2018, and including but not limited to stone walls, pillars, and gates. Also requiring a heritage alteration permit is for construction of an addition to a principal building or accessory building. And the final under this bylaw is any other alteration to the exterior of a principal building, including but not limited to walls, windows, decks, and roofs. So those are the areas that a heritage alteration permit would be required prior to a conservation area being put in place and the control period lapsing. The recommendation this evening is that Council consider first, second, and third reading of the Heritage Control Period Bylaw number 4739. And with that, Your Worship, that's my presentation.
Thank you, Mr. Anderson. Councillor Green.
Would you like a motion then moving the recommendation?
We can have first and second, and then we can have a discussion.
Okay, I'll move first and second reading. Second.
And seconded. Okay. Would you like to speak or ask questions?
I don't think so. I think it's pretty straightforward. I think that we've discussed this earlier, so.
Yep. Is there any questions of staff? I think it's worth, if nobody else has any, I'll just, from a clarification perspective, what, reading this bylaw, I think it's helpful in plain language, maybe just to explain, it does not prevent changes from happening during the control period. However, it requires a heritage alteration permit to undertake that. Could you just explain quickly what that means in real terms for people in the affected area?
Certainly. So, for example, if the district were to receive a building permit application for a new home in the area, because of the control period bylaw, we would require them to make application for a heritage alteration permit. Part of that process is that there would be a staff review, and if there are heritage values, there could be Heritage Commission review, and then the permit would proceed to Committee of Whole, and then as a draft permit, and then to Council for consideration of approval. The review in terms of a heritage alteration permit in this context is basically determining whether there's heritage value in terms of the proposal that we receive under, say, building permit, and then looking at any impact that proposed alteration, if there is any proposed alteration to the heritage values on the property, that would be reviewed as part of a HAP. The second component of this is if there are registered or designated properties adjacent to, say, the property that we had a building permit application on, consideration would be given to impacts under the heritage alteration permit on those adjacent properties, and particularly looking at issues of siting and setbacks of a new home in relation to those heritage properties. That's the principal focus you take when you're looking at the context for a heritage alteration permit. So the heritage alteration permit in this example that I'm providing, it considers if there is heritage value, if there are any alterations proposed to the heritage values, but it also needs to address or look at whether there's an impact on development rights as part of that heritage alteration permit consideration. So generally speaking, we don't see heritage alteration permits being approved that have limits placed on the development rights that are associated with zoning on a property. So with that, Your Worship, that's the scenario when we receive a building permit under a control period heritage alteration permit.
Thank you. That was helpful to me, hopefully to somebody else. Councillor Ney, you had a... Oh, no, it's just you're moving.
Just one thing that was quite helpful. Thank you, through Mayor, to Mr. Anderson. With a heritage alteration permit under this control period, you've talked about heritage values, alterations, and impact. So, are those the same sort of criteria that would be used under once the this permit is removed after a year and we're working within the HCA? Are the same considerations for a HAP heritage alteration permit the same, or are they different? Is that what you're speaking to?
Mr. Anderson?
Yes. Can we just call it a HAP? With respect to a HAP under the control period, basically you do look at the heritage values and you look at any alterations that are proposed to those, and you consider a permit, say, for a new building in that context. When we move into a heritage conservation area, there are basically some new items that are introduced, one of which is identifying protected properties and non-protected properties, and protected properties on a schedule. You also, as part of an HCA, you have a set of guidelines that are introduced. That there's a set of guidelines that apply to protected properties, and a set of guidelines that would apply to the non-protected properties. So there are, again, a different set of guidelines. And in terms of the process, there would be, it would depend on the type, the category of property that you were in terms of the process that you would engage in under an HCA. So there is a difference, I guess, is the bottom line, and there's more applied to protected property under an HCA. compared to the control.
Thank you, Mr. Anderson. Councillor Patterson?
Yes, thank you, Mayor. And another question for Mr. Anderson. Just for clarification, then when the OCP is amended to include the HCA in its bylaw, that then the amended OCP with the HCA in it takes precedence over this. Is that correct?
Mr. Anderson?
Supersedes it.
Yes, the control period is designed to allow preparation of the HCA. So with an HCA adopted in place, then the rules, if you will, around the HCA apply, and the control period is no longer in force.
Thank you. Any other questions or comments? Okay, we have a first and second reading moved. Seeing no other discussion, I will call the question. All those in favor? Opposed? None opposed. And we'd have third reading still here tonight. Oh, someone wants to get here. Third reading, thank you. Can I have a seconder?
Second.
Moved and seconded, thank you. All those in favor? Opposed? Unopposed. That concludes that portion of the pieces. We are required to read aloud the reasons for moving in
I
camera.
move that in accordance with Section 91A of the Community Charter, that the open portion of the meeting of council be adjourned and that a closed session be convened to discuss personal information about an identifiable individual who holds or is being considered for a position as an officer, employee, or agent of the municipality or another position appointed by the municipality.
Second.
Moved and seconded. All those in favor? Opposed? Unopposed. Thank you very much. Thank you, everybody, for coming out tonight. And we will have a now adjourned in camera. Thank you.